Her HOA tried to take her home after 11 years of trust. A woman sat in a courtroom fighting for her home, not against a stranger, but against the neighborhood she had trusted for 11 years. The homeowner had lived on Birchwell Court since her early 30s, a quiet cul-de-sac in a mid-sized suburb, the kind of neighborhood where people still brought casseroles when someone had surgery. She had served on the beautification committee, organized the July 4th block party 3 years running, and considered the HOA board president, a man she had known since their children played Little League together, one of her closest friends. That friendship, as it turned out, was the core of the problem. In March of the preceding year, the homeowner received a certified letter informing her that she had voted in favor of a bylaw amendment at the November annual meeting. An amendment that authorized the HOA to levy special assessments up to $8,000 per household for capital improvement projects. She had not attended that meeting. She had been in Phoenix caring for her mother following a hip replacement. And yet, according to the official minutes, her signature was there. Neat, confident, and completely fraudulent. The special assessment arrived 6 weeks later. $4,200 due within 90 days for the resurfacing of the community tennis courts she had never once used. When she called the board president to dispute it, he told her calmly that she must be misremembering, that the meeting had been long, that people signed things and forgot. She filed suit the following month seeking $47,500, the assessed amount, legal fees, emotional distress damages, and the reversal of the bylaw itself. In court, the homeowner's attorney presented a simple, devastating argument. Their client had been in Arizona from November 3rd through November 19th. Her flight records, her mother's hospital discharge papers, a pharmacy receipt from a Scottsdale CVS dated November 9th. All of it placed her 5 states away from a meeting she allegedly signed off on. A forensic document examiner testified that the signature bore several hallmarks of simulation: inconsistent pen pressure, an unnatural slant, and a baseline drift suggesting the writer was copying rather than signing naturally. The homeowner herself took the stand and described the moment she read that letter. She said it felt like a robbery, not of money, of 11 years of trust. The HOA's defense attorney pushed back methodically. The board maintained that the sign-in sheet was genuine, that 4 other board members had witnessed the signatures collected, and that the homeowner may have signed a proxy document before her departure. He pointed out that the forensic examiner's methodology had been challenged in prior cases, and that document analysis was far from infallible. The board president took the stand composed and credible. He spoke about the deteriorating tennis courts, the unanimous community support, the proper procedures followed. He expressed sadness that a long friendship had come to this. He seemed, to many in the courtroom, genuinely hurt. Then the HOA's own evidence broke the case open. In an effort to demonstrate proper meeting conduct, the defense submitted security footage from the community clubhouse, footage that showed members arriving and departing on the night of November 9th. What it also showed, in 14 seconds of incidental footage near the sign-in table, was the board president's wife, standing alone at the table, flipping through the sign-in sheet, pausing, writing something, then walking away before anyone else entered the room. She was not a board member, she had no administrative role, and the timestamp on that footage, 6:47 p.m., 11 minutes before the meeting was called to order, placed her at that table at precisely the window when late additions to the sign-in sheet would have gone unnoticed. The board president had submitted that footage himself. He had not watched it carefully enough. The judge did not deliberate long. She found in favor of the homeowner on all primary counts. The forged signature was invalidated, the bylaw amendment was voided, and the HOA was ordered to refund all special assessments collected under it. A total of $61,400 returned across 15 households. The homeowner was awarded $12,750 in legal fees and documented distress damages. A referral for potential criminal forgery charges was submitted to the county prosecutor's office against the board president's wife. The board president resigned the following week. The homeowner told a local reporter she didn't feel victorious. She said she kept thinking about the casseroles, the block parties, the way he had coached her son through 3 seasons of outfield in the rain. None of that was false, she said, and somehow that made it worse. The couple moved out of Birchwell Court 4 months later. The homeowner stayed. Here's the question the case leaves behind. If someone who genuinely believes in a community, who built it, maintained it, celebrated it, is capable of protecting it through betrayal, does the community itself become something worth protecting?